What did he do to make this house so evil?
What is a non-disclosure agreement, also known as an NDA? A non-disclosure agreement is a legal contract that establishes a confidential relationship between two or more parties and is designed to protect sensitive information from being disclosed to unauthorized third parties. NDAs are commonly used in business negotiations, employee agreements, and partnerships. There are two types of NDAs. The first is unilateral, and this type describes an agreement where one party discloses confidential information and the other party agrees to keep it secret. This is common when a business shares sensitive information with a potential partner or employee. The second type of NDA is a mutual NDA, where both parties share confidential information and agree to protect each other's data. This is often used in joint ventures or collaborations where both sides have sensitive information to share and protect. The key elements of a non-disclosure agreement include confidential information. The NDA should clearly define what constitutes confidential information, ensuring that both parties understand what is protected. The obligation of the parties. The obligations outline the responsibilities of each party regarding the handling and protection of confidential information. The duration of confidentiality. The agreement will specify how long the information must remain confidential, which can vary based on the nature of the information and the relationship between the parties. There are also exceptions to NDAs. Exceptions are information that becomes public knowledge or is independently developed by the receiving party. And lastly, legal recourse. The non-disclosure agreement provides legal remedies in case of a breach, allowing the injured party to seek damages or other legal action. When is it in your best interest to use a non-disclosure agreement? We're going to discuss that now. NDAs are typically used in situations where sensitive information needs to be shared, such as in business partnerships when two companies consider a merger or collaboration. They may share proprietary information that needs protection. For employment, employers often require employees to sign NDAs to protect trade secrets and sensitive business information. For consulting and freelancing, when hiring consultants or freelancers, businesses may ask them to sign NDAs to safeguard their confidential data. And since non-disclosure agreements are legal contracts, there are, of course, consequences for breaching non-disclosure agreements. Violating an NDA can lead to serious legal consequences, including lawsuits, financial penalties, and damage to professional reputations or relationships. The injured party may seek compensation for any losses incurred due to a breach. You may or may not be familiar with the fact that non-disclosure agreements are commonly used in reality TV between the networks and the cast members. Most of the examples I could think of and that I researched came from the TLC network, which broadcasts the 90 Day Fiancé franchise. Several cast members of the 90 Day Fiancé franchise have come forward making claims about non-disclosure agreements with the TLC network, stating that these non-disclosure agreements are unfair and even sometimes bordering on predatory nature. One couple was Matt and Amani, who starred in season 11 of 90 Day Fiancé. And they claim that they broke their NDA with TLC to expose secrets related to the season that they filmed, and this led to significant public scrutiny for the couple. Additionally, Danielle Jabali from season 2 of 90 Day Fiancé and 2 different seasons of Happily Ever After, which is a 90 Day Fiancé spinoff, spoke out about the low pay for cast members and the importance of maintaining a job while filming. And apparently, her discussing these topics was potentially a breach of the NDA. And the last example I wish to discuss involves Statler Riley. from 90 Day Fiancé The Other Way Season 6, and she exposed her former partner Dempsey as an alleged scammer and a cheater.
Multi-billion-dollar shows, that's the important stuff. This is the Learning Channel, or it used to be the Learning Channel. I think now it's HBO. I don't know what that was on. But at the end of the day, it is good to learn and to not support abusive people and show that stuff. And it's not good to have lies out there. Our own mental health is so important. Is the money good for the show? No. In fact, I think it probably could be taken to court. I think when you add up all of the actual hours worked for the pay, I think that at least the first season is probably below minimum wage. And I'm eager for somebody to look into that further so we can get a class action going. I don't think it will be me, however, I'm more focused on the mental health aspect of it. The producer's goal is to have drama to show you guys it is a show it's reality TV. Reality TV is, at the end of the day, trash TV. It is meant to make you feel better about yourself. I used to watch 90 Day Fiancé. I don't watch it anymore. I just wish the reality had been filmed. The reality of my life had been filmed, because it wasn't. It's so, you get a schedule, you know what I mean? You get a schedule, being where you are told which places you're going to go, what things you're going to feel, what conversations you're going to have. It's all scheduled.
In my research for this episode, I scoured the interweb for details about non-disclosure agreements within reality TV in general. NDAs are rumored to be used commonly for reality TV, usually to protect developing storylines that the network wants revealed only in their episodes. And as it turns out, many NDA breaches and concerns are settled through a process called arbitration, meaning they are conducted outside of the court without record of the results. And this has many advantages, mostly for the network, for these big corporations. This arbitration process mostly benefits these corporations because they have all of the leverage, the finances, and the resources that a lot of these cast members don't have. While many cast members of reality TV have reported signing NDAs for various shows, the details of these NDAs remain largely unknown. On occasion, cast members have divulged portions of their NDAs that are unfair or unethical in nature, often claiming that these agreements instill unsafe occupational conditions and force members to film when they're emotionally compromised or not feeling like it's safe to film. Some have accused TLC producers specifically of instigating fights between cast members to drive up viewership. Reality TV networks have also been accused of intentionally casting problematic personalities, despite the alleged unethical and illegal conduct demonstrated by these problematic cast members. In fact, the viewers of the 90 Day Fiancé franchise voiced concerns on social media with a particularly troubling character known as Big Ed. Despite leaked recordings of schmabuse adjacent behavior, he was kept on the show for many seasons as they moved him around to various spin-offs.
You told me when you were drunk the other night that you would rather sleep with Alex her than me.
Oh,
a.m. You don't come to bed. You don't cuddle with me. You don't do anything. And you're so insecure over someone being attracted to me.
Liz, you're the one that got upset and walked away from the restaurant and left me stranded. You drink too much and you just start walking home. Why do you hang out with people you shouldn't hang out with?
I'm not hanging out with anybody because you know what? You don't let me hang out with anybody.
Because they're all trashy. I've never called Liz fat. I'll drop positive hints. And I know I have to work on myself too, but I've never called her fat.
Likewise, viewers were quick to alert TLC to Renee's poor conduct during season 7 of 90 Day Fiancé Before the 90 Days, as she frequently verbally berated her blind partner throughout their airtime. This led to her and her partner Chitty breaking up and declining to attend the season finale. Tell all, it is TLC that has reported the narrative that Renee and Chitty declined to show up to the tell all despite rumors and whispers that they weren't invited back to the tell-all by TLC because of Renee's behavior, and also possibly because of how the content that TLC aired actually made the network look pretty bad because it was really bad.
That little false Christian and his parasite are giving are that I didn't go to the tell-all because of that guy's not worth it. He's never been worth it. I would never do something like that. I would never even consider something like that. So for him to be telling the whole world, curse you, okay, Chitty? I didn't attend the tell-all because, for one, I was not allowed to confront the whole situation. And two, you wanted to take your sister and your brother and one of your little friends to go try to, like, basically fight with me. I'm not in for that. So therefore, I said no.
Fans of the show felt that the network's actions were disgraceful, and they criticized them for failing to protect a vulnerable person from Renee's vitriol and cruelty. This opened the eyes of many viewers, which led them to boycotting the show. Now we're going to discuss some civic or more historical cases where NDAs were ruled unenforceable in court. The first case is Overby versus Mayor and City Council of Baltimore. And this happened in the U.S. Court of Appeals 4th Circuit on July 11th, 2019. What happened? Baltimore conditioned many police misconduct settlement payments on a non-disparagement/non-disclosure clause that would withhold part of a claimant's settlement if the claimant later spoke about the underlying events. One claimant, Ashley Overby Underwood, spoke publicly and the city withheld part of her settlement. The ruling. The 4th Circuit held that the city's routine use of these non-disparagement or gag terms in police misconduct settlements was unconstitutional and unenforceable as applied. The clauses amounted to hush money that waived claimants' First Amendment rights and suppressed speech on matters of public concern. The reason the NDA failed is because the court found strong public interest in the First Amendment specifically, and concerns where the government, i.e. the city, uses settlements to silence discussion of alleged official misconduct. A non-disparagement clause imposed by a government entity in that context could not be enforced. The opinion explains the constitutional problem and calls the practice impermissible. The second example was between Diamond Assets LLC and Godina. This took place in the Wisconsin Court of Appeals on July 14, 2022. In the case of Diamond Assets LLC versus Godina, an ex-employee known as Godina was sued under a contract that included a post-employment confidentiality NDA provision. The trial court dismissed the employer's complaint, and on appeal, the Wisconsin Court of Appeals reviewed whether the confidentiality clause was an enforceable, restrictive covenant under Wisconsin law. In the ruling, the Court of Appeals held the confidentiality of the NDA, specifically the provision, was unenforceable as a matter of law because its definition of confidential information was overbroad under a Wisconsin state statute. Restrictive covenants must be reasonably and narrowly tailored, and the clause could be applied to virtually any workplace detail. And the court used hypotheticals to show the overbreadth of this confidentiality. The NDA in this context failed because the court focused on the sweeping definition of business operations, vendor characteristics that could hypothetically forbid disclosure of mundane workplace facts. Wisconsin law treats confidentiality clauses that function as post-employment restraints as restrictive covenants subject to strict reasonableness review. If unreasonable, they are void. When signing an NDA, it is crucial to understand the purpose, contents, and potential implications of the agreement. Here are some key points to consider before signing an NDA. Understand the purpose. Know the reason for the NDA and what information is being shared. And this will help you determine the scope of confidentiality and the obligations that will rest on your shoulders. Review the scope. Ensure the NDA clearly defines what information is confidential and what is not. This is essential to avoid unintentional breaches of confidentiality. Understand the duration. Know how long the NDA will be binding and any potential exclusions to the agreement. Know the consequences. Be aware of the potential consequences of breaching the NDA, such as legal action or financial penalties. Negotiate terms. If necessary, negotiate the terms of the NDA to ensure that they are fair and to protect your interest. By carefully reviewing and negotiating the terms of the NDA, you can ensure that your confidential information is adequately protected and that the agreement is fair for both parties involved. In summary, if you're ever curious about an NDA or you find yourself considering one or needing to sign one out of necessity, I encourage you first and foremost to seek legal counsel from a licensed and qualified professional that is a lawyer. I am not a lawyer. And from an educational standpoint, NDAs are essential tools for protecting sensitive information in various business contexts, fostering trust and collaboration while mitigating the risk of unauthorized disclosure. Anyone entering into such an agreement should be prepared to follow the terms set forth in the contract. And that's why it's so important to have a professional lawyer look over these contracts before you sign anything. It's really important to make sure that whenever you're faced with any type of contract, that you don't allow for elements of coercion or being persuaded. Even if the person offering you the contract or giving you the contract puts pressure on you to make a decision in that moment, just know that you don't have to. Don't fall victim to their peer pressure tactics. And with that, that's all that I have for this episode today. Please let me know in the comments if you have ever signed an NDA, if you've ever drafted an NDA. Maybe you're a lawyer and you specialize in NDA type contracts. I'm very interested to know more about them. And just a reminder, I'm not a lawyer. I'm not claiming to be one. Please do not take this episode or any of its contents as legal advice. If you need legal counsel, please seek counsel from a licensed professional attorney. Also, let me know in the comments what you think about these NDAs and NDA terms that are being discussed by people in reality TV. If you have a different example that you want to discuss that I didn't mention today, go ahead and leave that in the comments. Thank you so much for tuning in. I'll see you in the next one.